welcome back to Securities Regulation. This is lecture number 24. We are about to close out on our discussion on the IPO of Burger King India Limited, and we had covered till MD&A in the last class, and therefore we'll be going on to legal and other information uh, in this particular lecture, right? So, legal and other information, this is a combination of what are the litigations by the company, against the directors, promoters, so on and so forth, as well as the approvals, licenses, and permits required by the company to carry on its obligation, to carry on its operations, right? Now, um, now to begin with, a company may have a lot of litigation in it, right? Um, in which case, it might make sense to highlight a materiality policy, right? A materiality policy to define what kind of litigation is material and what kind of litigation may not be as material, right? So here we have the materiality policy, which is a policy adopted by the board, in each case involving our company, the promoter, and the directors, right? All right. So on October 24th, 2019, the board adopted a materiality policy, which includes any claim which exceeds the amount which is lesser of 1% of the total revenue. So if a claim exceeds 1% of my total revenue or 1% of my net worth, right, as per the latest restated financial statements, a decision which might affect the decisions in other cases, even though the amount involved may be less than 1% of the total revenue, right? So, for example, uh, if there are multiple claims being made, or multiple cases being filed on a similar cause of action, in which case that too would be material, right? Any other outstanding litigation which may not meet these thresholds, but where an outcome against the company, would materially and adversely affect the business operations or financial position of the company, right? All right. So let's see. You've got some litigation against our company. So effectively, when you're doing a real diligence, you'll have access to all of the litigation information about the company, all of the paper books, which means that you'll need to sort of concisely put together a disclosure for each of the cases that are within this materiality policy. So, who filed the case? What kind of an application was it? Under what law? In relation to our restaurant, in relation to the cause of action, right? Our restaurant located at Rajiv Chowk, which is operating without obtaining a police license as required under the Delhi Police Act. This matter is currently pending. Now, all of these matters are currently pending. Now, earlier on, what SEBI used to want is, or what SEBI used to ask for, is the next date of hearing. Now, because dates of hearing change from time to time and they change quite frequently, depending upon the kind of application or the kind of litigation you have, this would frequently change as well, which meant that a lot of energy would go into figuring out when the next date is. In more recent years, SEBI has done away with that requirement. So effectively, um, the name of the party and what have they done, under what section, what is the cause of action? In this case, the presence of a noxious substance in the cheese veggie burger purchased by one of our customers. Subsequently, what has happened? A charge sheet has been filed, and the matter is currently pending. Right. So, if there are any legal actions being taken by statutory authorities, that comes in this litigation chapter as well. There will be plenty of food and safety related um, litigations and orders against the company, as is par for the course for most food and beverages companies. These are, of course, going to be specific to the company at hand, and it becomes very, very important for you to go through what the matter is for each of these litigations, and to figure out a short description and a disclosure for each of these matters, right? Any litigation involving our promoter, there is no outstanding litigation involving the promoter. Litigations against our directors, there is apparently one of our directors um, under the Serious Fraud Investigation Office, and the matter is currently pending, right? So, any litigation against our group companies, we should have identified our group companies and what those litigations are. Any taxation matters to be listed separately. Um, how many creditors do we have on a consolidated basis, and what is the outstanding dues as of date? Now, this information you should be able to get from the financial statements of the company, right? Um, and then a negative disclosure that accepted as disclosed in MD&A. The there are no matters which will materially and adversely affect our operations or will affect the value of our consolidated assets to pay our material liabilities. That's it, right? So the litigation chapter is also fairly short, but the information that you will need to gather to sort of put together the litigation chapter, that information is going to be fairly vast when it comes to a real diligence. Right. So then you have government and other approvals. These are all the approvals, licenses, permits that are required for the company to operate. So obviously you'll need incorporation details, which you already have, the permanent account number, the GSTIN, and professional tax registrations as required under separate state laws. Um, there will be approvals, specific approvals related to business operations of the company. Now, a quick trick over here is to figure out another company that has filed a DRHP, which is substantially in the same industry or the same sector as your company, which means that if you have a power generation company, look at the DRHP of other power generation companies. Look at what are the permits, licenses, and approvals that they operate under. And then you go back to this company and say, all right, do you have the approvals, permits, and licenses under these laws, right? So these again are going to be industry specific, right? A statement that we've obtained the relevant registrations under employment laws, whether that's shops and establishments, or in the case of manufacturing companies, the Factories Act, if there's Contract Labor Regulation Act, and so on and so forth, right? Our group companies. Who are our group companies? This will be, again, um, these are companies that are promoted by our promoter, right? So those are our group companies. So Harry's India Private Limited, you'll need to know the incorporation information, the nature of activity. So effectively, the main objects clause, just cull out one line from there. That should be fine. Financial performance, you will not need to put in at all, right? So effectively, for each of our group companies, the name, when was it incorporated, nature of activities. That's all that you'll need to put in for your assignment, right? The same is repeated for all of the other group companies. Whether there's any litigation involving your group companies, any of your group companies that have become sick or under winding up or insolvency, any group companies that have made losses, this again you won't need to put in, whether they are defunct, the nature and extent of interest of group companies in the promotion of our company. So, do our group companies have any shareholding or any interest in the promotion of our company? Any common pursuits between our group companies, whether they're in the same line of business, and so on and so forth. Any related party transactions between the group companies. And that's it, I think. Yeah, that's it. Now, other regulatory and statutory disclosures, now from this section onwards, it's more or less a copy paste job, right? Because you will not be able to proceed with filing with the DRHP unless you've taken other regulatory approvals under SEBI and that you've statutorily disclosed made certain disclosures as required under SEBI ICDR, right? So all of this is mostly a copy paste job for the purposes of your understanding. You will need to take a look at the eligibility of the offer, whether it's going under 6.1 or 6.2 of ICDR, right? Um, Again, most of these disclosures and disclaimers are, again, a copy paste job. You are not required to draft this chapter at all for the purposes of your assignment. Of course, in a real DRHP, you will be required to draft this, right? All right. So that's pretty much it for the regulatory chapter. I'm going to skip terms of the offer because this is again something that is typically drafted in consultation with the book running lead managers. And this is where it becomes fairly technical, and which is why I'm going to skip this bit. Again, it's not really necessary for you to understand in detail what this is going to be, but it might help you to understand the offer structure a little bit. So, for example, let's say our company this is an offer of blank equity shares for cash, each at whatever price is discovered, aggregating to so many shares, so much million rupees, comprising of a fresh issue as well as an offer for sale, right? And so the number of shares available for allotment for QIBs, non-institutional bidders or high net worth individuals, and retail individual bidders. So remember, this is under 6.2, so not less than 75% of the net offer to public. So you go, not less than 75% of the offer size shall be allotted to QIBs. 5% will be available to mutual funds only, and for non-institutional buyers, not more than 15%, and for retail, not more than 10%. Right? Um, Bid lot is the minimum number of shares that you will need to bid for in order to make a successful bid. Allotment lot will be usually the same as bid lot. Trading lot is usually one equity share, right? Okay. Just a reminder that in case of anchor investors, the full bid amount shall be paid by the anchor investor when they're submitting their bids. For all other bidders, for all other potential shareholders, they will use the ASBA format. All right, I'm going to skip the rest of the offer section. Really not relevant for us. Right. The last section that is really relevant for us is the main provisions of the Articles of Association. Now, in most cases, any private equity or venture capital investors or any institutional investors that are already there in the company, um, they they tend to sell out their shares during an IPO. But there may be cases where an institutional shareholder might just say that, look, I am willing to stay on in this company for a longer duration. In which case, I will keep some shares in my company for now. In such cases, the institutional shareholder may have certain rights, certain special rights, including a board seat, including certain information rights that will that will carry forward even after the IPO. In any case, there are certain articles of association that will need to be mentioned um, in the DRHP as well. The reason being that when somebody becomes a shareholder in a company, they are actually entering into a shareholding agreement which is encapsulated in the articles of association. Now, if you go back to VB Rangaraj, you'll notice that the Supreme Court said that any special rights given to a shareholder that is not there in the articles is not going to be enforceable. This was later on, there was a huge debate over this, and the present sort of position of law is that of Rangaraj. So when I'm making a bid for the shares of in an IPO, I'm going to become a shareholder, which means that my shareholding is going to be subject the um, to the terms and conditions under the Articles of Association. As a result, it is important for me as a potential shareholder to know what are the terms and conditions of my shareholding. So, how do we alter capital? How do we increase or reduce the authorized shareholding? How are shares allotted under the Articles of Association? Can the company do a further issue of shares, lien and forfeiture? All of these are standard terms and conditions under the Articles of Association, right? So effectively, this could be a copy paste job as well. So if you find in your articles of association that there are these terms that have been mentioned in your articles and they've been mentioned in a DRHP as well, all you need to do is simply copy paste the disclosures made under the articles or the DRHP, right? In this case, I don't see any special rights. These are fairly standard terms and conditions under articles. This you should have studied in company law. This you will find in Schedule 1, Table A, I believe, right? All right. Transfer of shares, right of first. Here we go. So there are a few special rights given to the promoter um, or certain shareholders in the company, which have been negotiated. So a right of first refusal, a tag along right. Um, so these again, you'll need to take a look at your articles, the articles of your company, to see whether there are any special rights. My sense is that there will be certain special rights. Okay. All right. The rest of the article seems to be fairly standard, right? And lastly, you will have material contracts and documents for inspection. This is basically done on a case to case basis, but usually any contract that has been made for the purposes of the IPO, that will be a material document. Memorandum and articles of association, certificate of incorporation, board resolutions authorizing the issue, um, those will all be material documents. If you have an employee stock option scheme, that will be a material document, and so on and so forth. So any sort of any contract that the company has entered into which provides for a significant amount of its revenue, or it provides for a significant amount um, of its raw materials, in which those all become material documents as well. And the last page is always the declaration, where the directors of the company declare that all the relevant provisions of the Companies Act and the guidelines or regulations issued by SEBI um, have been adhered to, and they certify that all these statements made in this draft red herring prospectus are true and correct. And this is to be signed by all the directors of the company and the chief financial officer. The declaration is a declaration is also made by the promoter in respect to in respect to the offer for sale. So, insofar as the shares that are being sold by the promoter, um, the promoter also says that these shares actually are owned by us. Any statements made by us as a promoter selling shareholder are true and correct, and we assume no responsibility for any other statements made by the company in this draft red herring prospectus. So, with that, we come to the end of the Burger King draft red herring prospectus. Using this lecture and the previous few lectures, about 4 or 5 lectures previous, you should be now in a position to be able to understand what goes into a DRHP, how that information is culled out from the company, and in what manner or what sense to arrange it.